The way that we would prepare for a case where there's either conflicting evidence or conflicting eyewitness accounts, or sometimes just an absolute lack of evidence. But for example, let's say that there's a policy for law enforcement officers to keep a body camera on, and something takes place and my client comes to me and he's got a broken arm, and he tells me that he was not resisting and he complied and he didn't do anything wrong. And I ask for the body cam footage and it's off. Well, I think that the lack of body cam footage there is very damning. I think that the lack of evidence very often is sometimes the strongest evidence of wrongdoing by the law enforcement officers. We particularly see this in a prison litigation context, because by the time you litigate a prison case, it often takes years. There's something called the Prison Litigation Reform Act, which stops inmates from filing lawsuits until they do a whole lot of administrative things. And by the time we actually end up in a courtroom, very often whatever footage or video may have existed is long deleted. In the cases that I've tried that involve prisoner civil rights in particular, the only times video footage is ever produced is when it's adverse to my client. And I use that to argue to the jury, if this actually happened the way the defendant claims, you would be watching the video right now. And I think it's a very compelling argument. And we see this with law enforcement officers as well. We see this with police body cam or dash cam. If there's footage that goes missing or is deleted or was never turned on, and then the police officer comes up with some story as to why that's the case, it's not gonna matter, because when he or she violates policy and now the jury doesn't get to see what happened, I think that juries are going to use that against that law enforcement officer. When it comes to analyzing conflicting eyewitness testimony or eyewitness descriptions of what took place in any given case, the first thing we need to look at is the credibility of each particular witness. If there's somebody who has no dog in the fight, who is a completely impartial bystander, that person obviously is going to be given more weight than a party to the case. Another thing to take a look at is whether the person is going to be credible. The bottom line is, law enforcement officers are going to be deferred to, generally speaking, by members of the public and by juries. So if it's just going to be a he said, she said between my client and a law enforcement officer, unless there's something else I can point to, whether it's destruction of evidence or not following policy, those are going to be cases that are going to be very, very difficult to prove. The exception is if, let's say, my client is also a law enforcement officer, or if my client is a member of the military. Police brutality is something that happens to everybody. It doesn't only happen to one kind of person. And there's no group of people that are necessarily automatically protected from being victims of police brutality. It can happen to anybody at any time, with or without reasonable or adequate motivation. So if my client is a law enforcement officer or a military officer, and he or she is a victim of police brutality, in that case, my client is going to have just as much deference in the jury's eyes as the defendant. And particularly in a case like that, if there's an absence of video footage or an absence of body cam footage, I think that that will go very strongly in our favor.